Okay, we're on page 41 in the purple book and 49 in the green book. We're talking about special education. It mentions that the first impetus for special education came from Brown versus Board of Education, that Supreme Court case which legalized or made illegal separation, the segregation of schools, and said that schools should be integrated. And based on that, then, the Council for Exceptional Children began to file some cases. So in the middle of that page, the foundation of today's special ed laws came with those two cases, Mills and PARC. So that's what they would ask you would be Mills and PARC are foundations of today's special education laws. So that's what you need to know about those two. So we find that this, for the first time, the courts then are ruling in favor of the rights of people who have educational handicaps, so that's the beginning of that. The Individuals with Disability Act, IDEA, was called PL 94-142 when it was passed. And this was in 1975. And this law you should be all aware of, I'm sure, because most of you are in mainstreaming classes. At the top of page 42 in the purple, and in the middle of page 50 in the green, it lists with bullets about 5 items. I won't go over those with you, but highlight those, so it should be important. And I understand there's a true false or two that deal with that. There is also a true false question that I hear it states that not fully mainstreaming a child is legal. Not fully mainstreaming a child is legal. That is true. You don't have to. Free and appropriate public education. Parents have the final decision on the IEP. You should all know what an IEP is. And they ask a true-false question. The parents have the final decision on the IEP. Also, they have another question in there which says that all students must have an IEP, and that's false. And those things are changing, by the way. Legal interpretations, looking at that, has been changing. Interpreting appropriate education. The Rowley case. And the Rowley case simply stated that the school has a responsibility to provide a door of opportunity, not a level of service. So in other words, we guarantee a floor of opportunity for all children, but we can't guarantee a level of service. We can't guarantee that the kid will be fixed. Say that. A new case, which is we just finished 51 in the green book, and we're on page 42. The Forrest case, F-O-R-E-S-T, reimbursement for public school tuition. The U.S. Supreme Court ruled that parents of a student with disabilities who unilaterally enrolled their child in a private school would be reimbursed for the tuition and their expenses. The decision was based on the public school district's inability or lack of providing the student with free and appropriate special education services. So this is Forest Grove School District. It's called the Forrest case. What it basically says is that if the public schools can't provide adequate service for a child, then they can be forced to pay private school tuition where the kid can get those services. Sort of fits in with that Zumbrest case sometime before. Least restrictive environment, that is the cornerstone of inclusion. And so basically the court pays particular attention to the unique benefits that students can get from being in the regular classroom. That's what it's saying as we're on 51 and turning over to page 43. So in that case, Daniel R. versus State Board of Education, they outline that saying a child can absorb a certain amount from being in a non-segregated situation. But if they can, then the courts have said it's okay to have them isolated or in a separate location. Most recent decisions show a shift. The Ninth Circuit Court, which affects us here in Nevada, have weighed academic benefit to students and the possible negative effects of mainstreaming on the classroom climate as equally important in determining placement. What that means is that they're now looking at those factors more. One of the most significant cases, as far as I'm concerned, is the Holland case, the Holland test. It's Rachel H. versus the school district, and they list 4 items here. I'm in the middle of page 43, and at the bottom of 51 in the Green Book. The non-academic or social benefits, educational benefits, negative effect on teachers and other students, and the cost of supplementary aids are the 4 criteria. I understand there's a multiple choice question which lists 3 of those, and as the other choice it says educational history, and that's false. That's what my student told me was on the test. The Rachel H. case is summarized here, and it goes over to page 51.
45 seconds.
45 seconds. And then it mentions the Ryan K. case, which is the opposite of Rachel. In other words, that one, the kid didn't meet any of the requirements. The kid was a mess, didn't gain any social benefit, didn't get any learning out of it, and was disruptive to the class.